Yeah, Chris, on the previous video, we talked about arrangement that you make in order to secure bail for your client. So let's continue on that. Let's just recap. First of all, a relative of the family of the accused or a friend will approach you with a view of asking you to help your client secure bail. So, like I've said, the information that you need to find out from whoever comes to you with this request for securing bail, you need to first find out as to when was the accused arrested, and I won't call him the accused, I'll say your client. You'll find out when your client was arrested. You will also try and establish as to where was the accused arrested, at which police station is he at, or prison. Sometimes people will be arrested and be in a police cell. After their first appearance, then they will go to a prison. It's either Kalagabusha, or in the case of Durban, it will be Westville prison. So it could be in one of the places. So you need to establish as to the whereabouts of your client, of your would-be client. The place of arrest is important, as it may assist the attorney in ascertaining in which court the accused is likely to appear, at which police station is in control of the matter, that is where the investigating officer is. The family or friends of the accused usually know where the suspect is, and at least they will know where he was arrested. Okay, so like I've said, that there are some specialized units within the police. Then in that case, a person can be detained in any police station within the jurisdiction of that unit. And also recapping, you need to establish what crime is the accused alleged to have committed. That is very important, because then you will see the magnitude of the crime, the seriousness of the crime. Whether is it a common crime like shoplifting, or just ordinary theft, or is it murder, is it rape, or rape of a minor? Those are all serious crimes that are determined by way of even the schedule. The schedule will be Schedule 6 instead of schedule, or the lower schedule. So in Schedule 6, we all know that you will have to establish that exceptional circumstances exist for your client to be released on bail. Also, it is important to know, you need to establish the investigating officer. It's normally called the IO. So you need to establish who is the investigating officer, so that you can find out whether the IO will oppose bail or will not oppose bail, because opposition of bail emanates from the behavior of your client during arrest, or the seriousness of the crime, right? And also you must establish as to which court will the accused appear, or if whether he has already appeared in that court, right? And the most important thing also is to establish the particulars of the accused, because you can't go there and say, when people ask you, who are you talking about, then you need to know this is Sibusi Somhlongo, ID number so and so, who resides at and is arrested is accused of having committed a particular crime, and you know when he was arrested, and you will also divulge that to the police. So you need the particulars of the accused, the full names of the accused, his residential address and the time he was and the time that he has resided in that address, and the family ties, and the place of employment if the accused is employed, the financial circumstances, because you need to know if this accused will be able to pay, and who, if not, if he won't pay, is there anybody who is going to be paying for this? Because as an attorney or as a lawyer, you cannot, I advise you now, never ever work for nothing, because you've got staff to pay, you've got stationery to buy, you've got your car to service, you need petrol to go to these places, and most importantly, what normally affects lawyers negatively is the question of rent. The rentals, you must rent your office. Offices can be very expensive, especially if you want to have offices in those high-class areas, because that also says a lot about you. If you are a lawyer and you've got an office in the remote areas of the city, then people won't go there, because first of all, there will be no parking. But if you go to these offices like in Mhlanga Rocks, in Pietermaritzburg, in Hilton, they are nice places. There's plenty parking. Even if people go there, they know that they are dealing with a professional. So if we want to choose to be in the remote areas, people won't come to you because they think you are taking chances. So it is important for you to know if your client will have money to pay, and also if you will have assets, and you need to know the amount of bail money that he can afford, and you take the personal details, including evidence of good character, previous convictions. That's very important, because when you are dealing with bail, you need to show that this person is of good character and he has no previous convictions and he has no other cases pending against him. This is a very important information that you need to divulge to the court, because if you fail to divulge that your client has previous convictions, has cases pending in other courts, once the prosecutor finds that out, and it's easy to find out, then your client will not get bail. You need to divulge that, failing which you are in trouble, right? And you must also, after having established that there are no outstanding cases, if there are, then you will need the details of that case, and also the details of the accused. If the accused is a flight risk, you need to establish that he will not be a flight risk, and you cannot lie. You must also establish whether the accused has travel documents, what is called passports, and also you need to establish whether there will be probabilities of a conviction, right? In this case, because what is important, you need to say that this person is wrongly accused, and he obviously will not be convicted of this crime, right? All particulars are crucial to a bail application. That is very important. You need to divulge everything. Don't hide anything. Do not hide anything. Otherwise, you will not. But what also is very important, when you are doing a bail application, do not ever touch the merits of the case. Do not put a defense. This is only an application for bail. We are not dealing with the main trial for now. So you can never, ever say anything about the merits of the case. Do not say, my client did not rape this child because my client was in Claremont when he, by the time people are accusing him of having committed the crime. Do not go there. Just apply bail, and I will tell you how it's done. I will show you how to draft an affidavit. But you must never ever, I need to stress this, because in my time as a legal practitioner, I have lost so many bail applications because I went on to try and prove that my client is innocent. That it's not the time for that. And if you do that, you must know that no magistrate will give you, because they will say, oh, you seem to know something about this crime. I think before you run away, because you've said something, the prosecutor hasn't said anything about you, the manner how you killed this person, but you are now describing how the crime happened, then the court is worried, because there could be more that you are hiding. Then the court won't be giving you bail. Even if you happen to be a presiding officer, once a lawyer comes to your court and start describing the manner in which the crime was committed during bail application, do not ever give that applicant bail, because you'll be making a grave mistake. That is a warning I'm giving you as both attorney or as a presiding officer. So that is important, right? So you give all the information about the applicant, that is now your client. This information will be necessary for the attorney's representations to the investigating officer and the senior public prosecutor. And should bail not be granted by agreement, it will be necessary to furnish this information to the court. Should this not be available, it may be obtainable from the accused personally once he has been located and whilst he is in custody. That now, which means now you will go and consult with the accused in the cells, and once you've consulted, you will then find out all this information so that you'll be able to present to the court or to the investigating officer to say this person doesn't have other cases, he's got no convictions, so please give him at least police bail. We'll talk about police bail, right? Now, let us now come to making arrangements for the appearance of the accused at court, right? If the attorney does not know who is the investigating officer of this particular case, he should telephone the police station. I've said that before. He should telephone the police station and find out who is the investigating officer, and whether the accused is in fact in the police cells and who the investigating officer is. The investigating officer should immediately be telephoned in order to ascertain when the accused will be appearing in court and on what charges, right? And whether there will be an objection to any proposed bail application. That is very important. If the investigating officer says no, we will object to bail, they must state their reasons as to why they are objecting to bail. Should it be possible to obtain bail from the police, that is now from the police station, the attorney should visit the police station and make arrangements for the accused to be granted bail forthwith. And like I've said, the only person who can grant bail at the police station is what is called a commissioned officer. A commissioned officer, I've explained, is those policemen whom, when you see a junior police coming to them, they will then come to attention and salute. Those are the commissioned officers. Now, police bail is in terms of Section 59, capital A of the Criminal Procedure Act. Right? Also, it's the same provision that the prosecutors now, that the DPP, that is not the Director of Public Prosecution, or a prosecutor authorized thereto by him, may, in respect of the offences referred to in Schedule 7. Remember now, you must know the schedules. Schedule 7 authorized the release of an accused on bail. So you can contact the police, the commissioned officer, or the prosecutor in terms of Section 59A of the Criminal Procedure Act and arrange that the accused, if he has committed an offense which is under Schedule 7, a prosecutor can authorize the release of an accused on bail. And then Section 59 is only applicable to crimes which are relatively fairly trivial, if you want to, if you know what I mean. Relatively trivial, like something like shoplifting, malicious injury to property. Those crimes fall under the Schedule 7. Okay. Then the prosecutor is required to consult with the investigating officer prior to the granting of bail. You cannot just grant bail because you need to know the situation in as far as the investigation is concerned, because the investigating officer might also be on a mission to use the same accused to go and point evidence or point other accused who are accomplices in this crime. So it will be immature for a prosecutor to release this person in terms of Section 59, capital A of the Criminal Procedure, prior any consultation with the investigating officer, right? If the latter is against the granting of bail, that is now the investigating officer. If he's against the granting of bail, the prosecutor has no authority to overrule him. So you see now who is boss at this stage of the investigation. The investigating officer is very important. If he says no, then nobody can release that suspect in terms of Section 59 of the Criminal Procedure. So it has to be the IO. So the IO is important. You've got to talk to the IO. I remember when I had a case some years ago where my client had stolen a vehicle at the casino, and he was denying everything, but I went and spoke to the investigating officer, and I told him, hey, this is the situation, I want him released on bail. And the IO said to me, but your client is very dishonest, because there are cameras at the casino. He was seen pressing a button to let him out, and he was seen by cameras driving that car. So his denial of not knowing what we're talking about is unfounded. So I went back to him and I told him, listen, this is the situation. You were seen on cameras. So if we keep on denying this charge, we are wasting time. You are wasting your own time. You won't get bail because there are cameras that saw you. So he then agreed, and what happened is history, because what we did, I asked him where the car was. He told me he had sold the car to a certain scrapyard in Clarewood. I went there and I saw the car. I took pictures. You must know now this is a crime, and it has been extended to other people. The owner of the scrapyard is now complicit to theft of motor vehicle. I took pictures of the car in that scrapyard. I brought it back to the investigating officer. I said, no, okay, I found the car, and can we now make a deal that the car is returned and my client be released on bail, or be released, totally released, that the charges must be dropped. That is what happened. I don't know how it happened, but the charges were dropped, and the car was returned to the owner. And but there were so many negotiations, because sometimes there's something called ADR. It is lawful to do ADR before your accused goes to trial. ADR means alternative dispute resolution. We will come to that. We've got that in our in our course outline. So we will come to the ADR. And I want to warn you, ADR, my friend, is today in jail doing 5 years because he did ADR. You need to be very careful when you are doing ADR. Whether you are an attorney or you are a prosecutor, especially if you are a prosecutor, don't ever get too much involved. Just negotiate and leave it there. What the two parties agree on, especially when it comes to monetary compensation, please don't get involved because you will sit in jail like my friend. I am warning you. Right? Okay. Then you will then talk to the prosecutor and talk to the IO. The IO, if the IO says okay, you can release, then you can be released. Right? Right. Now, this is what you need to know. There is something called after hours bail. Okay. Let us talk about after hours bail.